My name is Robert Burke. I'm an attorney at MacElree Harvey. I handle a lot of estate litigation, and as part of that, I'm putting together a multi-part series on what estate litigation is, how you can avoid estate litigation, and things that you should try to do to assure that when you do pass away, that there isn't a lawsuit that's challenging your will or challenging your wishes. This is the third part of my series, and what I'm going to talk about today is guardianships. Pennsylvania is one of the oldest states in the country. Where we live, Chester County, Delaware County, Bucks County, these are the oldest counties. It's an aging population. So what we're seeing issues with people's capacity, people who are suffering from various things, dementia, or other things that are affecting their mind, and maybe impacting the manner in which they're able to live their lives. And so what the Pennsylvania law allows in situations like that, it allows the appointment of a guardian. And the guardian will come in and can handle the individual's finances, or the health care for the individual, or both. And the law in Pennsylvania is pretty strict as to when a guardian should be appointed, and it should be. Because what you're doing when a guardian is appointed, the courts recognize you're taking away that person's liberty. You're taking away that individual's right to choose what that person wants to do with their money, or what kind of health care they're receiving. So these are the most basic things that people have a right to, and with the guardianship, those are being taken away. So the first thing the court looks at when evaluating a guardianship, they look at what's called the least restrictive alternative. And what the least restrictive alternative is there a situation where the alleged incapacitated person maybe has already selected who they want to make decisions? Has that individual filled out and executed a power of attorney so that someone can take care of them? If there is a valid power of attorney, the courts are going to be inclined to not appoint a guardian and to allow the individual who is the agent under the power of attorney to make decisions for that person. And that is the best practice, because you don't have the extreme appointment of a guardian, and yet you still know that the alleged incapacitated person is being cared for. The other things the court looks for is trying to promote autonomy. And what that means is the court wants, as much as possible, the alleged incapacitated person to still be able to make choices, where they live, what doctors they see, what they want to do with their property. Do they want to give their property away to others? Do they want to make gifts? The court is going to encourage autonomy for the individual, the alleged incapacitated person, to the best extent possible. And all this is geared towards making sure that the alleged incapacitated person is cared for, is not being taken advantage of, and is able to make the choices that that individual wants to make. So those are the things that the court looks to when discussing guardianships.